All right, welcome back to the video lecture series. I am today, talking about tort law. And tort comes from the French word tort, which refers to wrong. And that's the way it's come across in the English language as well. So we refer to this as civil wrongs. So you might be asking, okay, civil wrong versus criminal wrong. That's correct. So when we talk about this body of law known as torts, we call it civil wrongs. So unlike criminal wrongs, where the end result would be jail or prison, prosecuted by a county prosecutor or a federal prosecutor, on this side of the equation, tort law really is the purpose of tort law or civil wrong law is to provide remedies for the invasion of various protected interests that individuals have in society. So the interference of these protected interests or invasions of these protected interests or privacy rights or safety rights leads to this body of law known as tort law. So it's a funny word, right? This concept, this word tort. But when I say tort, I just mean civil wrong. Now, one action in society that results in injury to a person could be both a tort and a crime. So although in tort law we'll be talking about some of these things called intentional torts, which is assault, battery, intentional infliction of emotional distress, you may say as a student, well, wouldn't that be a crime? And the answer is yes. So one act that injures a party or infringes on a protected interest of another individual in society can both be a tort and a crime, meaning that two lawsuits could kind of work parallel to each other. The injured party could call the prosecutors, and the prosecutors or the police could arrest the individual for the act, and then later the individual would be charged in the criminal law setting, which that lawsuit would be filed and brought by the county on behalf of the injured party and the general interest of protecting society. And then on the other side of the equation, the injured party might say, well, wait a second, I was also, my rights, my protected interests were violated, so I want to sue that individual as well, seeking some kind of remedy for my injury. And most of the time what we would be seeking is monetary damages. So we would be seeking from the party who caused my injury or affected my interest, my protected interest, some remedy, and typically that remedy is in the form of money, monetary compensation. So we would seek to sue that individual for money. That's not to say that we couldn't sue in a tort setting for something other than money. We could sue for what we call injunctive relief, which is to force a party to do something or ask a court to order them not to do something. But typically, in these civil intentional tort cases, monetary damages is what the parties are seeking, or the injured party is seeking. So with that in mind, this is the kind of damages that you might be requesting. So when we talk about damages in a tort setting, we have compensatory damages and punitive damages. And compensatory damages are really damages that compensate the victim for the direct harm that can be proved by the invasion of the protected interest that we're asserting. So these are what we call, they can be economic damages, lost wages, maybe the actual injury to your person, so medical expenses related to the care of the and curing of the injury. It can be damage to my automobile if it's a traffic accident. Those are called compensatory damages. They compensate or awarded damages to reimburse for actual losses. The goal of these compensatory damages is to kind of put that victim back to a position that they were in prior to the tort occurring and the injury. So make them whole again. On the other side of the damage equation is what we call punitive damages. And these types of damages are really meant to punish the wrongdoer and kind of try to, in a way, prevent this kind of egregious conduct or reprehensible conduct from occurring again. And so there's I have posted a quick kind of damage cap rules in California for personal injury cases, and you can kind of look over that at your leisure. But generally speaking, in California, these kind of punitive damages or punishing the wrongdoer, non-economic type of damages. And when I say punishment damages, we're talking about damages for, pain, suffering, emotional distress, mental anguish, loss of quality of life, emotional trauma. These are the types of kind of non-economic damages that we often see asserted in a punitive damage case. And so typically these are in addition to any economic damages that one might get, which compensate for the direct harm that resulted from the injury. So punitive damages, there's some interesting rules on punitive damages, and many states are kind of adapting and adopting new rules as it relates to punitive damages. California is one of those states, and so take a look at the posted material, but generally speaking, punitive damages, or what we call non-economic damages, are capped in California, but they're only capped for medical malpractice claims, and they're currently capped as of January 1st, 2025 at $430,000 for non-fatal medical malpractice claims and $600,000 for medical malpractice claims that end up to be fatal. This law was passed and has a increase per year to try to get the damage awards up to something that I think the legislature thought was more fair, because this is a cap. When you think about it, what they're saying is if you're injured, let's say you go to the doctor and the doctor commits malpractice and you're severely injured from that, the most that you can get in a non-economic punitive damage sense would be currently that $430,000. So you could get all of your compensatory damages recovered, but if you went for, if it was egregious conduct on the part of the doctor, egregious meaning horrible conduct, just negligent beyond belief, you could only get $430,000 for that negligence. So, this is a kind of a societal issue, I suppose, and one that's worth discussing, probably over coffee or something, to be honest with you, but this idea of whether capping damages should be allowed or not. But in California it is. They don't cap all punitive damage claims, but they do cap medical malpractice damage claims, non-economic damage claims. And so take a look at that posted material. If you have questions, let me know. Let's move kind of on from damages and talk more about the classifications of torts, and then some specific torts that you read about and that we're covering in class. So we classify torts in two ways. We classify them in terms of intentional torts and what we call unintentional torts, or what we call the tort of negligence. So we have two classifications: intentional torts and unintentional torts. Unintentional torts are called negligence. The intentional torts, the difference between an intentional tort and an unintentional tort or negligence is really in the title itself, is that intentional torts have two primary elements that's common to every intentional tort, which is that there's a voluntary act and intent to commit that act that resulted in the harm to the other party. So you have this intent element that must be proved if you were to file a lawsuit against someone for an intentional tort. You're having to prove that they intended this particular tort that you're suing them under. And we'll look at some specific torts as we go through the PowerPoint slides. Whereas in negligence, you're not proving that there was intent. In fact, in the negligence claim, you're just asserting that they fell below a reasonable standard of care. So there's no intent element. You're just showing, hey, they didn't act as a reasonably prudent person would under those circumstances. And because of that, they injured me, and I'm injured, and so I'm suing under this theory of negligence in this broad thing that we call tort law. So let's start with intentional torts, and then I'm going to do another video this week on negligence. So let's start with the intentional torts. and then we'll move to negligence or the unintentional torts in another video. And we'll talk about defenses as we go through towards the end of this discussion. So you can see, so let's just kind of quickly run through some of these intentional torts. And remember, kind of the key thing to remember about intentional torts is, and when you're studying law for that matter, is you're going to read what the tort is. And so intentional tort of assault, you read the elements of what that intentional tort is. So it requires that it requires that the tortfeasor, the one who commits the tort or the tortious act, must do so with that intent to do it and a voluntary act. So the first tort that we have is the tort of assault. And so, as I said, contained in the elements of this particular cause of action. And when I use that phrase cause of action, I'm just talking about a theory of law that one would assert if they were going to sue another party and seek a remedy for injury or damage that's occurred to them. And so when I use that phrase cause of action, that's what I mean. And when you first start to study law, some of these phrases can be kind of confusing, but when you think about it, that's what we're doing. In any lawsuit, we're trying to find law. We're going to have a factual scenario or a basis for our lawsuit, or we believe we do, and then we're going to find the law that we think has been violated or infringed our law or our freedom that's been infringed upon, at least under this concept of torts, this civil wrong. And then we read the law, applying our facts, and argue that that individual should be liable for this specific tort that we've sued them under or used as a basis for our lawsuit, our cause of action. So if we were going to sue someone for the tort of assault, which is an intentional tort, voluntary act with intent, two elements. So as you read the intentional tort of assault, what does it say? It says it says an intentional threat or act that places the victim in fear of reasonable apprehension of an immediate harmful or offensive touching or contact. Any intentional or unexcused threat of immediate harmful or offensive contact, words or acts that create in another person a reasonable apprehension of harmful contact. So the tort of assault is just that, right? Is this idea that one with intent places someone in an immediate fear of harmful or offensive contact. Words or act that create in another person a reasonable apprehension of harmful contact. Act with intent. So one acts in a way that is intentional and or unexcused and causes another to be immediately fearful of harmful or offensive contact. That is the tort of assault. And you can see there's an intent element in this tort. Now, another tort is called battery, and this is can be distinguished from assault. They seem very close, but this is sometimes defined as just a completed assault. If the act that created the apprehension up here in assault is completed and results in harm to the plaintiff, it is called a battery. So harmful or offensive contact with another person without justification, consent, or excuse. That's battery. Harmful or offensive contact with another person without justification, consent, or excuse is battery. So again, we're looking at this individual tort, an act by the individual, the tortfeasor, with intent. And again, the tortfeasor is the person committing the tortious act, the one who is committing the tort. So in the act of a battery, this is the completion of that assault, right? Only now there's some sort of contact with the individual that has completed that assault, and they did it with intent, It's unexcused, right? There's no justification for it. There's no consent. There's no excuse. There was contact. We call that battery, and that is a actionable tortious conduct. So an important point about this kind of concept of battery exists in this language of harmful, harmful or offensive contact with another. So a lot of students will say, oh, okay, it has to be harmful. There has to be some kind of sustainable injury that's prevalent, bruising, broken bone or something like that. But in reality, tortious conduct can be merely offensive and actionable. For instance, a random kiss or spitting on somebody might not be considered so, quote, harmful, right? There's no broken bones or anything like that. But that offensive contact with the individual is also actionable under tort law as a battery. Physical injury doesn't necessarily have to take place. Now, when you're suing someone for a tort, there has to be some measure of damages. So although technically there doesn't have to be physical injury, there does have to be some kind of damage. But again, remember when we were talking about damages, as I scroll back up to look at damages, we can talk about medical expenses, lost wages, but we can also talk about non-economic damages like emotional distress, anguish, suffering, trauma from the event that is emotional in nature and not necessarily physical damage. This is actionable damages, and in California can be compensated. In most states, you can ask for compensation for these damages as well. So remember that although the tort says, as the act with intent, always we add in this idea that there must be some kind of damages. Otherwise, why would you sue an individual? Now, they could be compensatory or punitive or economic or non-economic damages. But keep in mind that there would have to be some kind of damages. Otherwise, why would you sue that individual? If you are not damaged by it and you end up suing that individual and you don't have any damages, you go to court and you're going to say, well, yeah, I'm suing them. I'm suing them for what? What are you suing them for? The court's going to say, okay, you win. You might do it. It's going to cost you money to file a lawsuit, but what would you do it for? The idea of winning the lawsuit, maybe you would, but it's going to cost money to do that. So unless there is some damages, then you're probably not filing that lawsuit. Another kind of interesting kind of notion as it relates to this battery claim is this idea of the contact can be made by the defendant or some force set in motion by the defendant, such as a rock thrown by the defendant. There's kind of a lot of kind of interesting cases as it relates to this kind of battery concept and this intent element and the concept of throwing a rock and hitting someone or aiming at one person but then hitting another one, and then allegations of, no, I didn't intend to hit you, therefore I'm not going to be charged with battery. But the law has said no, that we're going to transfer that intent from your initial attempted victim to the other one. Maybe you would allege, okay, I threw the rock in the air over a crowd, but I did not intend for it to hit anyone. No, nice try, but the law is going to say no. I mean, you acted with this reasonable degree of certainty that an injury would result from your actions, or substantial certainty that an injury would result from your actions. Therefore, that intent is there. Right? You can contrast this with, okay, I took the rock, I saw an individual, I threw it at them, and I hit them. Call that specific intent, but the intent is there. It's easy to establish, as opposed to I threw the rock in the air over a crowd and it hit someone. Oh, I didn't have intent. No, that's called general intent, and the actor knows with substantial certainty that the conduct or contact will result. That's still intent. So if you were to see that on like a hypothetical or a test question, remember that is true. There's even cases of people kicking out chairs that people are sitting on, and so they don't actually touch the individual, but they touch something that's connected to the individual, and that is also a battery. right? You kick the chair leg of a chair that someone's about ready to sit in or is sitting in. They fall and injure themselves. That's tortious conduct. That's intent to make the contact with harmful or offensive contact with an individual. The individual was injured, and the battery claim could be justified. Whether the contact is deemed offensive is also going to be termed or determined by this reasonable standard, reasonable person standard. And so if you think of hypotheticals in your own mind, you might be running through this idea of, well, what about this? What about this? And really, we would just have to discuss it on a case-by-case basis. Does this reasonably seem to be offensive or harmful? And if the answer is yes, then it could be actionable. Another tort in the reading, and I'm going to just kind of go through some of these kind of quickly, but you can read through these yourself. But this is called false imprisonment. And false imprisonment is an act or omission on the part of the defendant that confines or restrains victim to a bounded area. It involves interference with the freedom of movement or to move without restriction. And so false imprisonment is a civil claim, a tort, that one could make if one is detained or imprisoned or held, confined to a bounded area, unable to escape by confined through on a part of the defendant by an act or omission as the tort establishes. Typically, we don't see omission. We see more of acts, which could be physical barriers, physical restraints, threats of physical force. There's even cases that say threat of economic force, right? You stay here, or you'll never get a job here, or you do this, or you'll never get a job here, type of statements. So we see some of these false imprisonment claims as it relates to this idea of invalid use of legal authority. I'm just going to give you an example here. So, you could, if you bound someone somewhere, like say you trap them in a room or something, and don't let them escape, that's false imprisonment, right? If you lock them in a room, that's false imprisonment. You did so, you intentionally confined a person to a bounded area with no reasonable means of escape, then that's false imprisonment. That's kind of classic and clear. But sometimes we see this kind of extended to these ideas of invalid use of legal authority. And sometimes in class I'll talk about this with students, and I'll ask, has anyone ever worked at Target or Walmart or any of these places? And invariably one of my students will say, yeah, I work at Target or I worked at Walmart. And I ask, well, what is their formal process on shoplifting and detention of shoplifters? And most of them say, oh, we're not supposed to do anything. And it's interesting. And then we kind of talk about why that is and why that's changed. Because when I was a kid, it was different. Shoplifters were grabbed by the individual security guards and they were taken to a room and they were put in a room and questioned, and it was, pretty extensive. But it's changed over time, and part of that is because of these lawsuits against Targets and Walmarts and these places for false imprisonment, for battery, for these kind of tortious conduct that results from the forcible detention of an individual. Even though they are given this legal authority to detain suspected shoplifters, what has happened in some of these cases is when you get the invalid use, this an unreasonable manner in which they detain the person, or they detain them for a unreasonably long period of time. And so then, as they did this, merchants were getting sued for either holding them for too long or being too forceful in their stopping of the individual and questioning and detaining of the individual. And so lawsuits came against these establishments for false imprisonment. Another reason why we're seeing, I think, kind of a increase in thefts from these types of establishments. Another tort that is in the textbook is this intentional infliction of emotional distress. This is kind of an interesting one, and we see this tort thrown in a lot with other types of torts. And so someone will kind of tag this one along with a battery or a false imprisonment or a defamation lawsuit, which we'll see in a second, they'll kind of add this intentional infliction of emotional distress. And what this tort says is that a person intentionally acts in a manner that reasonably may be expected to cause severe mental distress to another. So, extreme and outrageous conduct resulting in severe emotional distress to another. So this is really a tort that causes that the basis for this cause of action is really that you're causing emotional distress on another individual by your actions. Can anyone think of anything off the top of their head where this might be a legitimate claim in today's society? Yeah, if you were thinking online bullying or harassment, I'm right there with you. Right? This tort, intentional infliction of emotional distress, is defined as extreme and outrageous conduct resulting in severe emotional distress to another. Now, to be actionable, the conduct must be so extreme and outrageous that it exceeds the bounds of decency accepted in society. But boy, when you look online and you see some of this conduct and statements being made and posted and published to other people, I believe that it falls in this exceeding the bounds of decency. And that's really the proof that's needed. So if you're filing an action against another individual for this intentional infliction of emotional distress, then you really would need to prove this element that it exceeds or transcends the bounds of decency acceptable in society. And it's done with intent. And it is extreme and outrageous conduct by definition, extending beyond, exceeding the bounds of decency in society. Another tort, defamation, or sometimes what we'll call harm to like a dignitary interest, is this idea of defamation. So defamation involves wrongfully hurting a person's good reputation. The law has imposed a general duty on all persons to refrain from making false, defamatory statements of fact about other people. Breaching this duty, right, this duty not to make false, defamatory statements of fact about another person is called defamation. Right? This protection of our dignity, our dignitary interest. It protects us from a false accusation or statement made that's defamatory or casts us in a unflattering, factually wrong statement, right? And so if we can prove that, then we have a cause of action for defamation. Now, so this idea of a false statement of fact, which is concerning the victim, it's published, and it damages the victim's reputation. So defamatory false statements of fact, harming a reputation of or concerning the victim who's filing the lawsuit, publication of this statement to a third party, and damage to that victim's reputation, right? This is what defamation says, right? The wrongful hurting of a person's reputation through false or defamatory statements of fact, published. It's concerning the victim who's filing the lawsuit, and the victim's reputation has been damaged by it. And so sometimes we'll break these out and we'll say, okay, was it in writing, which we call libel, or was it orally saying something, which we call slander? So as you look through, as you look through here on the outline, it's kind of highlighting some of the elements of this cause of action. And remember, when I started talking about intentional torts, I said there's always two broad elements for every intentional torts: an act and intent. And then as we go through each one of these torts, we're kind of starting to see, okay, well, this tort has a little bit more. It's those two elements are always kind of underlying every one of these intentional torts, but then they're adding in for each specific tort that we're looking at. And so, as I said, defamatory false statement of fact of or concerning the victim, published, and damaging the victim's reputation. Those are the four elements of this defamation claim. And so what's interesting is, as you can see in the outline, we start to look at, well, what issues arise as it relates to defamation or defamatory statements. And often an issue is whether the statement was made as a fact or a statement of an opinion. So if you've ever heard someone say, well, in my opinion, this person is a criminal. If sometimes if we add the language opinion, then defamation is kind of taken off the table, because what we're really saying then is it wasn't a statement of fact. It was an opinion. And defamation really requires on this statement of fact of or concerning the victim, that puts the victim in a false light. It's published to a third party, and it damages their reputation. But if I start off by just saying, oh, in my opinion, I have this First Amendment protected freedom of speech right, and so I can utter opinions about individuals, corporations, companies, and I don't know, Chipotle or Starbucks. In my opinion, I don't particularly enjoy their food, right? Or alternatively, let's say I was talking about, I won't use an actual company, but let's say I was talking about Tapatlia, tortillas and Mexican food. And I said they use, cat for their meat, right? Then you're asserting a fact. Even if I said, in my opinion, they use cat meat, this would border on a statement of a fact, which could be actionable. But you can see where I'm going with this idea. If in order to be actionable under this kind of theory of defamation, it must be a statement of fact. So this could be an arguable issue, right? Some might say, well, just because you said opinion, you still were asserting fact. That's a good claim. So we would argue about this. A lawsuit, there's always going to have two sides to the story, two lawyers, to a victim and a person who made the statement, the defamatory statement. We're going to argue about that. They might say, oh, it was just my opinion. I even said it was just my opinion, but the nature of the statement might have been more factual in nature. And so this could be an issue, which I'm presenting to you in this outline as well. Publication requirement, as I said, it must be published. Communicating directly to a person factually and saying something defamatory directly to an individual with no one else present is not defamation. If I'm speaking to someone and I specifically tell them something about them, ridicule them, but do it in a false light or a defamatory statement, a false statement that could in fact harm their interest, but I'm just saying it to them, it's not actionable as defamation. Defamation requires that publication of that statement or ridicule or hatred to a third party. And remember, that must be false and defamatory, right, to be actionable as well. So always in this kind of discussion of defamation, students will say, well, what about, publications, magazines that always put public figures, actors, athletes, politicians, entertainers in a false light, or say misleading things about these types of individuals, people that put themselves out in the public light, if you will, public officials or public light or entertainers. So interestingly enough, this is a defense to defamation claim. First you can see privileged communications are also a defense. Absolute truth is a defense, but also this concept of public figures. So in general, public figures are considered fair game, and even if there's a false statement being made about them, because they have put themselves in the public eye and are considered public figures, the defamation lawsuits aren't going to go forward under those four primary elements. What the law has done is they've added some elements, and the elements that they have added in these public figure defamation lawsuits is that the false or defamatory statement has to be done with actual malice. And actual malice is defined as a statement that is made with either knowledge of the falsity of the statement or reckless disregard for the truth of that statement. So that's a big deal, right? So let me recap. So in other words, if you're considered a public figure and a defamatory statement is made about you and you sue someone, so the defamatory false statement is made of or concerning the victim, and it's published, and it's damaging your reputation, so I filed a lawsuit. Well, I would have to show that by what we call a preponderance of the evidence in a civil suit. However, if it's a public figure, now I have to show that the statement was made with actual malice. In other words, that they knew at the time of making that statement that it was false, or they did so with reckless disregard of the truth. This is a high standard. This is why public officials don't win their defamation cases very much, because I would have to show this additional element, this reckless disregard of the truth, or that they had knowledge of the falsity of the statement at the time that it was made. Okay, so let's keep looking at some of these other torts that are presented in this chapter, and I'm going way over my 15 to 30 minute lecture. I want to skip through this one. Take a look at invasion to the rights of privacy in your notes and in the book. This is an interesting tort as well, especially as it relates to this kind of concept of revenge porn and other things, which unfortunately we're seeing more of in society today. But this invasion of the right to privacy and appropriation is really a tort based on this idea that we have the right to be private and free from public eyes, and that protecting this privacy is a safeguard that tort law protects, and the invasion of this privacy and the appropriation of our likeness and our person, and this published kind of invasion could be actionable, either done through placing someone's intrusion into personal affairs or placing someone in a false light for publication. I want to talk quickly about this fraudulent misrepresentation, because this is a tort that we see more often in business. And so the last three torts I'm going to quickly talk about are these torts that I think might be more apropos to our business course here. But this fraudulent misrepresentation is an interesting one. And so in short, we call it fraud, fraudulent misrepresentation, or fraud. And so fraud is a tort, and the elements of the tort are this: is a misrepresentation of a material fact, done so with intent to deceive the other party, and induce the other party to rely on this misrepresentation, fraudulent misrepresentation. So I make a fraudulent statement about something with intent to induce that party to rely on that misrepresentation. The other party justifiably relies on that, and they suffer damages because of that misrepresentation. So those are the elements. In the outline, we say leads in misrepresentation that leads another to believe in a condition that is different from the condition that actually exists. This is done through a false or incorrect statement, a fraudulent misrepresentation, right? A false or incorrect statement, an intentional deceit, right? As I said, the way I define it is a misrepresentation of material fact. In other words, intentional deceit, a false statement, an incorrect statement that is done with intent to deceive the other party or induce that other party to rely on that statement, and they rely on that statement and they act on it and are harmed by that fraudulent statement. And so we see this in business, sometimes in real estate, maybe a financial advisor. Maybe many of you have heard the name Bernie Madoff. So Bernie Madoff was a financial advisor, investment guru who would trick people into believing that he was investing their money for them by extravagant claims of success in investing. And so what Bernie Madoff would do is just ginned up or generated a bunch of false return statements for his clients. He would not actually invest their money. He would just pretend to invest it and then send them these false returns as their money allegedly grew, although it didn't. He would send these fraudulent statements to them, misrepresenting the condition of their account balance, and this is fraud. So if we look at the definition, a misrepresentation, misrepresentation of a material fact, yes. Meant to deceive another person, yes. The other person reasonably relies on the information or the statements made, yes. They act on those statements by giving him more money or allowing him to keep their money to invest, and they are harmed by that fraudulent conduct and statements. This is a classic example of fraudulent misrepresentation. Another example might be that a real estate agent or a homeowner is selling a home and they know that it has mold or it gets hit by golf balls constantly, and they go out and they re-side the house so that you can't see the golf ball damage, or they paint over the mold and then sell the house and don't let the other parties know about this. And so this is also a fraudulent action. The cover-up is the law treats as if that is a statement in and of itself, a misrepresentation made, and that person relies on that cover-up, if you will, and acts on it by buying the house and later discovers that it's infested with mold. You could have an action for fraudulent misrepresentation. Down here is an interesting one, which we call negligent misrepresentation. The key difference, this is a tort or action arises from negligent misrepresentations as opposed to intentional misrepresentations. And these aren't as common because the law requires that they didn't have a reasonable basis for believing its truthfulness. So we're asserting not the intent to induce through fraudulent means, but more of just you didn't have a reasonable basis for uttering that, and that was negligent, and because of that we're suing you. Okay, the last two are directly related to these kind of business torts, and we have wrongful interference with a contractual relationship and wrongful interference with a business relationship. Wrongful interference with a contractual relationship is one that we see, I wouldn't say frequently, but exists out there and is worth noting. And the elements of this particular tort exist when there is a valid enforceable contract between two parties, and a third party knows that this contract exists between these other two parties, and that third party intentionally induces one of those parties to breach the contract. We call this wrongful interference with a contractual relationship. Now, this is interesting because if we pause for a second, we say, well, wait, it's a contract. Why wouldn't they just sue them in contract? Well, remember, a tort is a civil wrong other than contract. So allowing a person to sue in tort for wrongful interference with a contractual relationship gets them out of the contract claim and into a tort claim. Now, we haven't studied contracts yet, but we will. But what's the difference between suing someone in tort and in contract? Remember, in tort, we had non-economic damages, punitive damages. In contracts, we don't allow a person to sue for non-economic damages, or what we call punitive damages. We only allow you to sue for those directly relatable, compensatory damages, which you can prove directly. And so in contracts, we're looking at this kind of measure of damages related to the breach and what the breach caused as far as damages, but not punitive damages or these kind of pain and suffering and non-economic damages that are allowed, or even just purely punishment damages for egregious conduct, which are allowed in tort cases that are not allowed in contracts cases. So when we allow someone to sue for this contractual relationship interference, we're letting them sue for the egregious nature of the contract, punitive damages, non-economic damages, just to punish the egregious nature of that conduct. If I were to just do the same thing in contracts, I could only sue for the breach of contract, which resulted in whatever damage I can prove based on the breach of contract, but does not allow for these kind of punitive damage awards that exist in torts. So this is an important one. Okay, so I'm way over my time here, but I wanted to quickly kind of point out that in the reading and in your outline here, you can go read. So I covered intentional torts to the person here through this lecture, video lecture, but if you want to continue reading on, there's also intentional torts against property and trespass to personal property, conversion, disparagement of property. So read through those on your own, and I will be posting a video shortly on the next part of this torts chapter that we learned, and this relates to negligence. So look for that to pop up on YouTube this week as well. And if you have any questions or comments or need help, always feel free to reach out via email or to set up a private Zoom session so we can talk about this stuff together. So I hope you're enjoying these video lectures, and you can sign up for these. You can follow me on YouTube, or as I've been doing, I will post these in the announcements so that you can see them and post them in the modules tab with the link when they're finished. So thank you.